Mr. Ramdeen. As you can see, Lord Stevens is having to join us remotely.
Yes, ma'am. Good morning, my lords. In this appeal, I, Gerald Ramdeen, and Mr. Tom Richards appear on behalf of the appellants. Mr. Peter Knox, QC, Mr. Fayed Hussain, Senior Counsel, and Mr. Robert Strang appear on behalf of the respondent. My lords, before I begin, would you allow me just to express my gratitude to the staff of the Judicial Committee. On the 1st of February, permission was granted in this appeal, and we're grateful that the appeal was deemed expedited. During that time, an order was made by the appeal panel on the 1st, and there were some very restricted timelines for the filing and putting together of this appeal. And we could not have done that on both sides without the assistance that the staff of the Judicial Committee has provided us. And I want to express my gratitude both to the staff at the registry and also to my learned friends in order to comply with all of we're happy that we've been able to comply with all of the directions as best as we can so that the hearing today can run smoothly, I hope.
Well, thank you, Mr. Ramdeen. I'll make sure that your thanks are communicated to the staff involved.
Thank you very much, my lord. My lord, before I get into the actual submissions, a very extraordinary event transpired overnight, and the facts of that are set out in a document, which is an affidavit of Ms. Aguilera, that we attempted to send to the registry this morning.
Yes, we have that. Thank you.
Thank you very much, my lords.
There's been a bit of a flurry of last-minute documents, but I think we have them all.
Well, I'm happy to hear that we have all the documents, my lord, but I was a bit surprised at 9 p.m. Trinidad time, which is about 1 a.m. this morning. I was informed that at 8:45, which would have been 12:45 English time, a deportation order was served on the First Appellant at the heliport in Chaguaramas where they're detained. And the facts of that matter are set out in the affidavit of Lisette Aguilera. My lords, I am very concerned about this fact and this development because the First Appellant and the appellants have been incarcerated now for almost a week less 16 months. The respondents in their written case have indicated clearly that the premise of their written case has been that there is a policy that is in place that doesn't require a deportation order to be served. But more troubling is the fact that they've provided the respondent herself on affidavit evidence in this appeal that is before this court has indicated the reason why a deportation order, or it is the policy or alleged policy of the respondents, why a deportation order was not served on the first named appellant. That being that deportation orders are not served on the appellants, and I'll take you to the reference in the electronic bundle.
Yes, we've read that.
Yeah. And last night, this alleged policy seems to have disappeared.
Yes.
And
well, if the deportation order was necessary in order to provide a lawful basis for the detention of the first appellant, then as of the early hours of this morning, there is such a basis, but it's only as from the early hours of this morning.
Well, I accept that proposition, my lord. The difficulty or the troubling aspect of this is that this deportation order has been served where we have a decision of the Court of Appeal in the Torres matter, which is in the additional authorities bundle, which has not been appealed to this court, and as it stands as we speak, is a binding authority on the immigration in Trinidad. Mm-hmm. And the Torres decision clearly sets out the fact that the Court of Appeal in Trinidad has decided that the making of a deportation order after an interim order similar to the interim order that was made by Madam Justice Quinlan Williams in this matter is an unlawful act. And it clearly demonstrates, my lords, from the appellant's point of view, that the making of that deportation order in circumstances where an interim order is in place that clearly sets out no step towards deportation ought to be taken by the respondents. A decision of the Court of Appeal that the respondents are aware of, because they were the respondents in those matters, says that the making of a deportation order in those circumstances is unlawful. And yet still, while we have an appeal pending before the Judicial Committee, the Minister of National Security, in less than 24 hours before the hearing of the appeal, sees it fit to issue a deportation order, which, respectfully, my lord, has to be unlawful.
I'm just trying to find the authority that you...
My lord, it is, and I can assist you, my lord. It is the Torres authority that is to be found in the additional volume of authorities. It's at electronic bundle, page 851.
Is this the supplement? This is the supplementary bundle? No.
The additional bundle, my lord.
Additional bundle. Thank you.
Oh, it's in our main... It's in our main bundle.
Main bundle.
Page 851.
Thank you.
It's at tab 7, page 932. What I'm going to refer you, my lord, is both the High Court judgment and the Court of Appeal judgment. So the judgment of Madam Justice Quinlan, who decided that matter, Torres, at first instance, is to be found at tab 7, which is page 932 of the additional authorities bundle. And the Court of Appeal.
This is Contrera.
Sorry, my lord?
932 is Contrera.
Yes, there are two...
It was a conjoint appeal, and there's one judgment, my lord. And I'm sorry for not pointing that out.
Yes, I've got it. Thank you.
And the relevant passages are to be found, page 932, page 944, paragraph 48.
Sorry, what was the second page reference, please?
Sorry, my lord. Paragraph 48, page electronic bundle number 944.
Thank you.
Yes.
And in the Court of Appeal judgment.
So what are you... I'm sorry, what are you taking from the judgment of at first instance?
Yeah, sorry, my lord. Paragraph 48
Yes.
are the facts.
Yes.
And it says, Coralza del Valle Marin Torres also entered the country illegally and alleged that her detention is unlawful.
Yeah.
Torres was quarantined pursuant to a quarantine order made on the 24th of November 2020. On the 30th day of November 2020, Torres sought relief by filing a constitutional claim, CV 2020-04080. By order dated the 30th of November, Charles J. ordered that the Attorney General, in quotes, is refrained from taking any steps to remove the claimant from the jurisdiction.
Yeah. Yes.
Pending the determination of this application. The court has not determined the notice of application filed on the 30th of November 2021. Meanwhile, a deportation order was issued on the 12th of January, and this application for the issue of the writ of habeas corpus was filed on the 26th of January 2021. My lord, could I then take you from there to electronic bundle number 9 page 949, paragraphs 63. And this is still the judgment of Madam Justice Quinlan Williams. You have it, my lords?
Yes.
In the paragraph 63, my lord. In the circumstances before this court, the detention orders are stayed by the undertaking given by the Attorney General and by injunction ordered by the court. There is therefore no legitimate exercise of power to detain the applicants. They cannot be deported. The applicants cannot be deported unless there are further or other orders made by the court. The respondent argued that the injunction and the court would add the undertaking does not prohibit the Minister of National Security from signing deportation orders. Section 29(2) of the Immigration Act gives deportation orders life, even if they are stale dated, unless and until cancelled by the Minister. It seems to the court that if the Minister of National Security chooses to issue deportation orders, as he has done in the circumstances of this case, then the only option available to him would be for an order to be made under Section 17 of the Immigration Act for conditional release or supervision. In the circumstances and based on the respondent's return, they have not satisfied the court that the applicant's detention is lawful. That is the judgment at first instance, my lord, where Madam Justice Quinlan Williams found that the making of the deportation order subsequent to the injunction order being made was contrary to the order and therefore unlawful and could not justify the detention because the order that was made, the injunction order that was made, prohibited any step towards deportation, and the issuing of the deportation order would have been a step towards deportation.
I see. Well, if you, I mean, I'm not quite sure where we're going with this, but if you consider that the making of the orders against the appellants was a breach of the injunction, then that's a matter for you to take up before the court in Trinidad.
Well, save and accept, my lord, that if the injunction order, if the deportation orders are the basis upon which the returns are based in answer to the application for habeas corpus, there can be no lawful authority to detain if those orders are unlawful. And that is exactly the position with respect to the returns. Well, the return that I will take you to in this matter.
Yeah.
The authority that has been advanced by the respondent for the detention of the second appellant in this matter is Section 16 of the Immigration Act.
Yeah.
And sections...
I'm sorry, before we leave Torres, is there anything in the judgment of the Court of Appeal you need to draw to our attention?
Yes, my lord. My lord, the judgment of the Court of Appeal is to be found at electronic bundle page 851. It's tab 3 of the additional volume index.
Yeah.
You have it, my lord?
Yes, we have that, thank you.
My lord, I'm at paragraph 100.
Well, what page is that on?
Page 878 of the electronic bundle. This is the Court of Appeal judgment delivered by Madam Justice Dean Armour. On the 16th of December, 2021, my lord.
Yes, I see.
Paragraph 100, my lord. The terms of the order of Charles J. are clear. That is Charles J. Muller being the injunctive order that the court is referring to. The Attorney General, as the representative of the multi-headed Hydra of the state, is preventing from taking any steps to remove the claimant from Trinidad. The first step that may be taken towards removing the claimant is the issuing of a deportation order, which was made against Torres, was in breach of the order of Charles J, and therefore ought to be set aside. We therefore agree with the judge's summary disposition of this issue. The detention is unlawful simpliciter, and there is no need to proceed further to consider the second limb of the Hadial-Singh principles.
Yeah. But in our case, does the injunction prohibit any taking of any step?
Yes, my lord. And
It's the same terms, isn't it?
It's the same terms. Yes, my lord.
Yeah.
Page 270, I think.
Yes, my lord. Thank you very much.
One view, wasn't that injunction far too widely drafted? Because what you wanted to prevent was the actual deportation of an individual. You didn't necessarily want to prevent preparatory steps, because if the constitutional proceedings failed, then why shouldn't the state have already made preparations of some sort or other for the immediate deportation of the individuals? An injunction is always wrong to compare it with what the terms would be in this jurisdiction. But my understanding in this jurisdiction, it's the actual act of removing the person from the state which is prevented, rather than any preparatory steps which can be undertaken.
Yeah.
I'm guided, my lord. Now, my lord,
But so in the present case, there was a deportation order I beg your pardon. Yes, there was a deportation order made before this injunction was granted in January.
yes, my lord, on the 12th.
Yes, yes,
The injunction order was made on the 18th.
yes.
I started off, my lord, by addressing the fact that the deportation order that was issued last night in relation to the second name appellant falls within the exact factual matrix that has been determined by the Court of Appeal in Torres.
Yes.
And therefore, in relation to the first name appellant,
We've lost Lord Stevens.
Oh, we've lost. I'm sorry. We've lost contact with Lord Stevens. We'll have to wait until contact is resumed. We're going to have to get our IT staff to come and sort out the problem, I'm afraid, Mr. Ramdeen. We'll adjourn for a few minutes until
As you please,
it's sorted out. Well, Ms. Ramdeen, it rather looks as though the order has been, the order doesn't, so far as the second appellant is concerned, on any view she's had a lawful deportation order served on her in January. The practical importance of the deportation orders served more recently is really in relation to the first appellant, because it's the only order that's been served on him. If that order is unlawful as being in breach of the injunction, then evidently you can apply to have it set aside. and the authorities, you've shown us, the Torres case seems to be with you. As Lord Stevens has pointed out, it may be that the minister might apply to have the injunction narrowed so as to enable a deportation order to be served. But these are matters that would have to be pursued before the courts in Trinidad. We don't have an application for judicial review of the order in front of us, and we're not a first instance court.
Well, my Lord, if I can address the question that Lord Stevens asked about the width and the breadth of the order that was made. What we have is that the High Court has made an order. The terms of the order, on the face of it, seems to be very wide as capturing any step towards deportation. It was open to the respondents to make an application to vary that order or to appeal that order. They have not done that. You also have before you, in the bundle of authorities, and the way in which I wanted to develop the submissions, my Lord, is that I wanted to take the court through the different steps as to how we got here, because the facts of this matter relate both to these two appellants and other persons who have litigation before the court that the board is aware of. There was one case where injunctive relief was not granted at first instance. It was refused. That is the Valeria matter. And we've put that transcript before the court. In that matter, the Court of Appeal granted injunctive relief in exactly the same terms as the orders that were granted at first instance in all the other matters. And the reason why I make that point, my Lord, is that the orders that have been granted preventing deportation in all of the matters are the same. They're wide. They prevent any step being taken towards deportation.
Well, they don't quite say that. They say any step to remove. If I'm reading the correct order, 270.
$270 million. The order granted on the 15th of December 2020, wherein the respondent, his servants, and or agents is restrained from taking any step to remove the applicants from the jurisdiction, be continued until the hearing and determination.
I'm sorry, we were looking at the order made on the 18th of January by Madam Justice Quinlan Williams. You're referring us to an earlier one?
No, my Lord, this is the same order at page 270 of the electronic bundle.
Yes.
That's the order of Madam Justice Quinlan Williams.
Any steps to... I see. Yes, so she was simply continuing an earlier order.
Yes, my Lord, and if you
So if that earlier order was in the terms that we read here, that would mean that the deportation order made in January 2021 was itself contrary to the injunction if you apply the Torres reasoning.
Yes, my Lord. And the reason why I'm on this point is because there was no application made at any point in time. As I understand the law, my Lord, even if the order is bad, you have to comply with it, unless it's set aside.
Exactly.
And therefore, if these are the terms of the order that bind the state, they must comply with the order. And if it restricts you from taking, in these terms, as wide as they are, the remedy is not to breach the order. The remedy has to be to either set it aside or appeal.
Yes, but if the fact of the matter is that deportation orders have been made, this court can't ignore them. They're not nullities on their face, as it were. If you're going to argue that they should be set aside because they violate the injunctions, then you have to apply for the setting aside of the orders.
But respectfully, my position is the way in which these applicants challenged their detention was by way of habeas corpus, so that when they applied for the writs of habeas corpus and the writs were returned and that is an issue that we deal with in our case. Applications were made on the 28th of January by both appellants. Writs were returned on the 29th. The writs are before you. The return is before you. On the return, my lord, there is no lawful justification that has been provided for the detention of the first appellant. The return deals only with the second appellant. And I don't want to stray into that area as yet, my lord, but in answer to your question frontally, where there are habeas corpus proceedings, and the law is that you must provide lawful justification, otherwise there will be release. If it is that you provide the lawful justification is a deportation order, and that order in itself is unlawful, it cannot provide lawful justification. Now, my lord,
but until now, I mean, this point wasn't taken in the courts below, was it?
yes, my lord.
Well, may I ask you this question? As I understand it, on the 12th of January, the deportation order was made against the second appellant.
Yes, my lord.
This order was made pursuant to the application made on the 15th of January, on the 18th of January.
Yes, my lord.
The injunction was continued on the 18th of January.
That's correct, my lord.
And it wasn't suggested at that hearing on the 18th of January that the continued detention was unlawful because the order for removal had been made on the 12th of January, contrary to the earlier injunction.
No, my lord, it wasn't suggested because that order that my lord is referring to, which was made on the 18th of January, is an order that was made in the constitutional proceedings to protect the applicants from being subject of deportation while their constitutional proceedings were afoot. And if one...
Well, I beg your pardon.
Sorry, my lord.
The injunction made on the 18th of January, which we're looking at on page 270,
Yes, my lord.
was a continuation of the earlier injunction, as I understand it.
Yes, my lord. It started on the 2nd of November, the 2nd of December, by the order of Charles J., and continued by the order of Rahim J., pending the hearing and determination of the appeal.
But it wasn't suggested that the deportation order made on the 12th of January offended against that injunction.
Yes, my lord.
Was?
If you... One minute, my lord.
If you look at the issues in this appeal, this just isn't an issue. You've got an issue that because there's no deportation order in respect of the first appellant, his detention is therefore incapable of being justified. That's the very first issue.
Yes, my lord.
And you've got a variety of points about essentially the Harding-Singh principles as applied to the second appellant. And
yes,
your argument really is that she's been detained for far too long and therefore ought to be released. But you're not, I don't think any of these, well, you do have an issue as to the lawfulness of a deportation order of the 12th of January.
My lord,
you do have that.
It's the second ground.
Lord Kitchen, if I can correct myself, the order of the 12th, there was no, you're correct, there was no challenge to the fact that the order of the 12th, that the deportation order breached the order of the 12th. What we argued was that there was a lapse. There was a lapse. If I take you back to the facts, my lord,
I mean, this is the subject, or at least part of the subject of ground 2, as I understand it.
yes, my lord, but I would like to just explain. The first order that was made in these proceedings, the first injunctive order, was made on the 2nd of December.
Should we have a look at that?
Sorry, my lord?
Should we have a look at that?
No, not for these purposes, my lord. I can, and if you wish, I will. But the first injunctive order was made pending the determination of the quarantine period.
Yes.
Right. When the quarantine period expired, a second injunctive order was made by Rahim J., pending the hearing and determination of the appeal in Valeria.
The date of that?
15th of December, page 26 of the electronic bundle.
Thank you.
Now, this is the important point, Lord Kitchen.
Thank you.
When that order expired on the 15th of December, when that order expired on the 22nd of December, I apologize. The decision in Valeria was given on the 22nd of December by the Court of Appeal. That is the matter that I referred to, in which injunctive relief was not granted in the High Court. And what I want to explain, my Lord, is this. When that order lapsed on the 22nd, because it was only pending the hearing and determination of the appeal, there was a period of time within which there was no injunction in place protecting the appellants. So that period of time would be from the 22nd of December to the 18th of January. And therefore, when the deportation order was made on the 12th, it was made at a time when there was no injunction in place.
Yeah.
So there could be no challenge to the fact that that deportation order was in breach of the order of the 12th.
Yeah.
What our case is, my lords, is that when the order of the 18th was made, any act of the state that would have contravened that order would be unlawful.
Yes. Yes, and you argued that the detention was such an act.
Yes, my lord.
Yeah.
And therefore, that is the way in which the case had been advanced.
Yeah.
But my lord, I'm worried about my lord's question with respect to whether these proceedings should have been akin to judicial review to challenge the order. Now, my lord, the position is the applicants are entitled under the Constitution, Section 523, to come to court, and the remedy of habeas corpus is a constitutional remedy that is guaranteed by the Constitution. They've come to court to exercise that right to habeas corpus.
Yes, but in the nature of things, the question whether the recent deportation orders, the ones made earlier today or yesterday evening, whether those are valid or not, applying the Torres principle, isn't an issue before this court.
To the extent, my lord, that we didn't have the deportation order until last night.
No.
So that our case has always been, in relation to the first name appellant, there was never a deportation order that could have authorized detention under Section 16. And what I think, one of the things that I think is important for the court to bear in mind is that a deportation order does not authorize detention. And that is a point that we made in all of the courts below.
Yes, we understand that.
Where you make the deportation order, there may be, it then opens up the Section 16 so that you can have detention pursuant to the deportation order. So that the deportation order, if you advance on a habeas corpus application, that the deportation order is the ground for, lawful ground for continued detention. Our case is simply the deportation order cannot provide that lawful justification.
Yeah.
I'm not saying that in this case, the return that was filed said two things. It made reference to the deportation order, but it was clear that the basis upon which the detention was continuing as advanced was Section 16, the Section 16 power. And our case has always been that the first name appellant, in order to justify his detention, is a prerequisite that you must have a deportation order. Well, we've had one now since last night. But for 14 months, and when the application was made, there was no deportation order. But more importantly, my lord, one has to have regard to the nature of the proceedings that were brought to challenge the detention. The habeas corpus proceedings require you to produce the writs that were issued, required you to produce the lawful justification. And if there is no lawful justification produced, which we say is the case with respect to the first name appellant, then the court has to release. The issue that the respondents have advanced, and the Court of Appeal, we say, erred, was that they say, as a matter of policy, deportation orders are not issued to children. Now, my Lord, respectfully, the policy or whatever policy that the immigration authorities choose to adopt cannot supplement the law with respect to what does the primary legislation require. The primary legislation requires that you must issue a deportation order. And the constitutional right to liberty requires that you can only deprive someone of their liberty by due process of law. The due process that you must follow is that you must follow the provisions of the Act. You cannot avoid the provisions of the Act by saying, I have a policy.
Yes, yes, we understand that. That point's well developed in your case.
And my Lord, what I think is even more important is that now that a deportation order is unchallenged and a deportation order has been served with respect to the first name appellant, the alleged policy and the reason that has been advanced by the respondent throughout the case, that the reason for not serving a deportation order on the first name appellant is that he can't understand. Well, after 16 months, that has disappeared because he's been served with a deportation order last night. Now, I don't know if the court requires me to go into the evidence that has been put forward in the respondent's case, but there's a very important issue, my Lord, that I think would answer the question that my Lord Reid has raised. And that issue is this. Well, by evidence, if I can ask the court, my Lord, to go to the constitutional proceedings. When I say the constitutional proceedings, electronic bundle number 1049. It's the last document in your electronic bundle, I think, my Lord.
This is the affidavit of Ms. Gandhi.
The respondent, my Lord, that is correct.
Yep.
Now, my Lords, do all my Lords have it? You have it? Yes. My Lord, in that affidavit, to be fair to my friend, my learned friends cited paragraph 8 of the affidavit itself in support of their case, in support of their policy or the existence of their policy. That is paragraph 8 of the affidavit.
Yes.
But, my Lord, I would like to ask the board to consider the exhibit that is exhibited as CGA1, and it is to be found at page 1063. And I want to make specific reference, well, I'll take my Lords to page 1067.
Is this a page headed up memorandum?
It is, my Lord. My Lord, you would see this is a document from the Ministry of National Security, Immigration Division, Chief Immigration Officer, to the Honourable then Minister of National Security, the Honourable Stuart Young, from the respondent, Chief Immigration Officer. If you look to the right, top right-hand corner, the signature of the Minister is there, agreed and approved, 20th of July 2020. So this was almost a year and 3 months before the facts that bring these proceedings before this court. And my Lord, can I ask the court to go to page 1069? And the last paragraph on that page, my Lord, starts with the words, the Honourable Minister.
Yes.
The Honourable Minister is advised that the removal of any foreign national from this country is required to be supported by some legal instrument.
No, sorry, I'm on the wrong page. I'll need to find it.
I'm sorry,
I'm with you now. Thank you.
The Honourable Minister is advised that the removal of any foreign national from this country is required to be supported by some legal instrument emanating from the Immigration Act. This may either be a rejection order, a deportation order, or a voluntary departure order. Failure to lawfully justify the removal of a foreign national, as I am advised by the division's legal officer, may amount to an ultra-vires exercise of power by either the Honourable Minister or the division, and is a clear ground for judicial review and scrutiny of the division's function. The Honourable Minister is further advised that no other law enforcement agency, inclusive of the Trinidad and Tobago Coast Guard, possesses any legal powers to authorize the removal of a foreign national from this jurisdiction. That authority falls squarely within the remit of the Honourable Minister and the Immigration Division. So the respondent is advising the Honourable Minister that in order for you to deport anyone, you have to have an instrument, a deportation order. This advice is in accordance with the provisions of the Immigration Act, as we have advanced.
Yeah.
And therefore, we say that with respect to the first named appellant, there was no deportation order. That is not in dispute.
Yeah.
And the failure to provide a deportation order renders the detention unlawful, because there is no lawful justification for that detention, and there is no the policy argument that my learned friends have advanced on their case can no longer apply, because they have now decided to serve a deportation order upon the applicant.
Well, as you say, whether it's right or wrong is really beside the point. I mean, a policy isn't enough to support the detention of somebody.
Yes, my lord.
Yeah.
So, my lord, Mr. Richards and I have tried our best to narrow these issues that are before this court as best as we can. And they are set out in our case, in the appellant's case, that is to be found at electronic bundle 469. And in summary, my lord, our position is this. With respect to the application of Section 16 of the Immigration Act, the common law has developed through the Hardy-Alsing principles and as set out in Ex parte R&I, as well as Ex parte Lumber and Mighty, which we have all put before the court, the way in which those principles are to operate. And if I can summarize, my lord, our position is this. On the first limb of Hardy-Alsing, which is that the power under Section 16 can only be exercised for the purpose for which that power was conferred. Lord Dyson in Lumbar has made it very clear that the implied limitation that Lord Wolfe was referring to in Hardy-Alsing is that the power of administrative detention can only be exercised to facilitate deportation. It can only be exercised to facilitate deportation. Those are his exact words. So, our case is, it doesn't matter whether the order, and when I say the order, I mean the injunction order, the distinction that is being made between an order that is made before or an order that is made after the injunction order is one that doesn't really make a difference in our case, my lord. Because in the case of an order that was made before, we say that the making of the deportation order is unlawful because it is in breach of the order. And in the case of the second appellant, where the order was made before the injunction order was made, we say that upon the making of that injunction order, if steps were entrailed to effect deportation pursuant to Section 16 or pursuant to the deportation order, once that order has been made, the authority to continue comes to an end. So that what we are saying in relation to the second appellant is that on the 18th of January, when Madam Justice Quinlan Williams made that order, detention, and if I can take one step back, Mullah, Hardy-Alsing, Lombard, and R&I make it clear, and there can be no dispute, there's no dispute between the respondents and us, that the purpose of, of detaining under Section 16 is only to facilitate deportation. Facilitating deportation is a step towards detention pursuant to Section 16 is a step towards deportation. Where you have an order of the court that prevents any step being taken towards deportation, our respectful view is that the Section 16 power is virtually eclipsed. In law, it's eclipsed. You cannot do it. And if you cannot carry out the purpose for which Section 16 has been conferred by the legislature, it means that you cannot detain.
Mr. Ramdeen, you repeatedly use the expression "a step towards deportation." Can you help me where we find those words in the injunction? Because the injunction to which we've been referred has the words "any steps to remove,"
well,
which may not be the same thing.
Well, my lord, any step to remove, if one were to examine those words, any step to remove, the making of a deportation order on a literal interpretation of those terms has to be a step towards removal. You can't remove without making a step. You cannot remove without making a deportation order. That is how we interpret it. Any step to remove. So that the making of a deportation order, as the Court of Appeal said in Torres, is the first step in removal. Because the only purpose that one can satisfy by making a deportation order is to remove. That is the purpose for which the power to deport is given under the Immigration Act.
Thank you.
I was just wondering if you could help me in relation to this. That is, if there is an application for an injunction to hold the ring for a couple of days, and the injunction is issued in these terms, exactly the same terms as the present one, the logic of what you're saying is that you then get to the result that no matter what the risks of absconding, no matter what the chances of reoffending, of offending are, there would be no lawful method of detaining a person. That the judge, in granting an injunction, had unwittingly, in effect, allowed the release of a person who ought to be deported and who ought to be detained because of the risk of absconding and the risk of offending. Wouldn't that be just an absurd result to achieve?
Well, my lord, it depends on the manner in which the injunction is granted and the terms of the injunction that have been granted. In a typical example is, if you go back to the facts of Hardyal Singh, when Hardyal Singh came before Lord Wolf, the respondent had asked for a few days to be able to put in an affidavit, to be able to satisfy the court as to whether they were holding the person to facilitate deportation. And the exact words of Lord Wolf were, hesitatingly, I would grant the application. They had asked for 1 week, and he had granted them 3 days. Now, what one has to balance, the question, Lord Stevens, is this. One has to balance the fact that this is administrative detention. This is detention without any review. And this is at the discretion of the executive. And the cases are very clear that where there are two options available in this type of detention, you must come down on the side of the liberty of the subject. And
my point was taking on what my Lord Lloyd Jones was addressing, and that is the word remove might be interpreted in a way that didn't achieve an absurd result.
There can be circumstances, my lord, as set out in your question, that it may be that something may happen within those few days that can cause that person, in terms of the risk of absconding, to abscond. But the principle that has been set out in relation to how that Section 16 power is to be determined is not in question, unless we decide to reverse Hardyal Singh and the way in which Hardyal Singh is to be applied. But what that would mean is that in addition to the purpose for the detention, which is clearly the implied limitation, we would be adding another category of case where there is some risk that the executive determines, and therefore you allow the executive to detain under an additional head. And the authorities just don't say that. We would have to create a separate head outside of what has been, outside of what the common law has developed, to be able to say that you give the executive an additional discretion under Hardyal Singh, apart from the fact that you carry out the statutory purpose. And that, my lord, is something that will go against all principles of basic principles of public law, because you would be allowing the executive to exercise a power that is outside of the remit that Parliament has given them. The courts have determined that this Section 16 is to have that implied limitation, which must only be exercised for the purpose for which it has been given. And this court will determine whether it is appropriate to go outside of that and add an additional limb based on the factors that Lord Stevens has set out in his question, which is absconding and the risk of absconding. And to answer it this way, Lord Stevens, I think the answer is to be found in the decision of the Privy Council in Tantilam, because in Tantilam, which is in the principal bundle of authorities, and I can go to the exact reference if you wish, but the Privy Council made clear in Tantilam that it is open to the legislature. It is open to the legislature to provide other exceptions and disapply Hardyal Singh if they wish. But that is not a matter for the court. The statute is there, and we must abide by the terms of the statute. And the common law has defined how that statute is to be interpreted. And if we wish to do something other than what the common law has defined Section 16, that Section 16 power to do, it is not a matter for the court. It is a matter for Parliament. Now, my lords, do you wish me to take you to that section in Tantilam and point it out to the court?
I think it would be a good idea for us to have a note of it anyway.
Tantilam is found in the principal bundle of authorities, my lord, at tab 9. And the passage that I wish to refer my lords to is to be found at electronic bundle, page 818, which is page 113 of the report in the appeal cases. And it is to be found at paragraphs G to H of that page, my lord. Their lordships, do you have it, my lord?
Yes.
Their lordships do not exclude the possibility that by clear words the legislature can confer power on the executive to determine its own jurisdiction. Say, for example, the power to detain were expressly made exercisable during such period as, in the opinion of the director, removal from Hong Kong was pending. In such a case, the court's only power would be to review the director's decision on Wednesbury principles. Where human liberty is at stake, very clear words would be required to produce this result.
Yes.
So, well, it goes back to the fundamental principle that the Immigration Act, by the Immigration Act, Parliament has provided certain circumstances in which the executive are allowed to exercise that power of executive detention. I don't think anyone can challenge the fact that the court will scrutinize that power very carefully to ensure that the exercise of that power of detention and the restriction of one's liberty is done in accordance with the statute. If it is that one wants to add to the remit of the power of the executive to detain in circumstances where there is a high risk of absconding or other circumstances, the cases are clear, where you have alternative challenges that stop the authorities from from executing deportation. That is a matter for Parliament. It is not open for the executive to exercise a discretion that is not conferred by the Act, because to use the words that have been set out in Lumber, it opens the door to the vice of arbitrariness and uncertainty as to how the statute is to be applied. And the vice of arbitrariness and the uncertainty in which a statute is to be applied will create a situation where the liberty of the subject would be at risk, and a very high risk at the discretion of the executive. And I would caution interpreting any section to allow the executive to have such a power. But I think what is more important, my Lord, is that Lord Stevens has demonstrated by an example what are the risks that can happen in a case where you have someone who is at high risk of absconding and you have just a few days in which you can facilitate deportation. Why to take the example the other way and say that in the cases that are before this court, you can see the result of what can happen if you allow that power to be exercised in an arbitrary manner or in breach of an order of the court, which is that you have two individuals who have been detained for 16 months. And even, my Lord, on the third limb of our argument, the Court of Appeal itself has said that, and we've challenged the reasoning of the Court of Appeal with respect to whether a reasonable time has elapsed, but the Court of Appeal itself has said that they expected that these proceedings would come to an end by the 31st of January 2021. And we're in March of 2022, and we're nowhere close to the proceedings having come to an end. So that one can see and understand the logic of the question that Lord Stevens has posed with respect to a high risk of absconding. But, my Lord, the case and the facts that are before this court demonstrate the manner in which the right to liberty can be cut short, can be sacrificed on the altar of executive discretion, because that is exactly what has happened in this case. You have a period of time in this case where, first of all, 14 months less 7 days has passed in respect of someone who they have no authority to detain. And the proposition, and I don't expect that my friend is going to say that, but the proposition that because you serve a deportation order last night, time is going to start to run with respect to that deportation order today, and say that he can be detained for a reasonable period of time, it's just one that is devoid of any logic. Because even in relation to that, my Lord, the position is simply this. My friends have taken the decision to serve a deportation order in relation to the first name appellant, to justify the detention of that appellant on the basis that the statute requires you to do that. This court will determine what view they take about that action. But what is very clear is that even if that deportation order was served last night, on the principles that the common law has developed, the same Hardial Singh principles, there is no possibility that the constitutional motion, which is the limit that is being placed on the injunctive order, is going to end anytime soon. And what the respondent is saying is that we should continue the 14 months for however long it takes, on the basis that the deportation order itself and the exercise of power under Section 16 will provide lawful justification for the detention of these two appellants. And our position, my Lord, is that is just simply contrary to the case law. Now, my Lord, the facts that surround how this case has reached where it has reached is simply, and is set out in the statement of fact and issues, is that there are 10 constitutional motions before the High Court. There were 8 applications for habeas corpus. And my Lord Reed, can I just indicate to you that a reading of the record of the proceedings in the court below, and it just came to me, is that you would see that the argument was taken in the court below that the applicants on the application for habeas corpus, an abuse of process argument, was taken by the respondents. The first limb of the respondents' answer to these claims in this case was that the going for habeas corpus was an abuse of process, which is the point that my Lord was making, whether we should challenge these proceedings in the courts of...
I wasn't seeking to make the point that had been made by the respondents. The point that was of concern to me, I mean, it's rather developed as a result of the discussions that we've been having, but it seems to me at the moment, you're saying the deportation orders served in the last 24 hours on the authority of the Torres case, where there was an identical injunction. On the authority of those cases, the deportation orders are violate the injunction.
Yes, ma'am.
And you say, I think, that they ought therefore to be set aside by the court, and that it can do that in a habeas corpus process, because the whole point of the process is these orders are being relied on as the lawful authority for detention. And if they're not valid, then the court should set them aside and declare the detention to be unlawful. Now, we'll be hearing at a later stage on behalf from the respondents, but I don't know. They may dispute the Torres approach to this. If they do, then there's a legal issue as to what the effect of the injunction in the terms that was granted, not to take any steps to remove, what the effect of that is. Now, that issue, I appreciate you might like us to deal with it. From our perspective, it would be an issue being raised before us for the first time, and it's not one that it's not one that's, I mean, nobody's to blame for, well, you're certainly not to blame for this, but it's not one that's been focused at all in the parties' written cases, because it's only just arisen.
My Lord, in your question, in your discussion, you've raised the issue, and I think it's quite important. You said there's a valid deportation order, and I think the description of being valid is one that is quite important, because our case, or I wish to submit to the court that if you have an order that is in breach, if you have a deportation order that is in breach of a court order, it cannot be a valid order. And I think the difference between what my lord is saying and what I am saying is the step that intervenes in between that, which is whether it should be set aside. Now, if you advance detention based upon an order that is in breach of a court order, it follows, I would say respectfully, that that exercise of power based on an order that is in breach of a court order cannot be lawful. And that is the case.
Yes.
Now,
yes, I perfectly understand the argument.
I just want to bring this, in fairness on the authorities, I think it's important for me to indicate to the court that there are two things. There are these proceedings that find themselves before the board. As Madam Justice Dina Mora explained, there were 4 sets of appeals, and there were 3 decisions that were given in relation to these proceedings. So there is a decision that was given by the Court of Appeal in this matter, there is a decision that was given by the Court of Appeal in the Torres matter, and there is a decision that was given by the Court of Appeal in the Gobin matter. That is the one that there is a transcript before you, my lord. We managed to get the transcript in time. Now, what I didn't mention earlier to you, my lord, and it is picked up on in the respondent's case, is that in the Gobin matter, which is the matter where there were 2 minors who had come before the courts and applied for habeas corpus, and a similar response was given to what was given in this case, which is we don't issue deportation orders to children. In that matter, the Court of Appeal held that the necessary precedent fact for the detention was absent, and therefore the detention in that case was unlawful. Now, that authority, my lord, is to be found in the alternative bundle of authorities. And
is that the one that's been said this morning?
No, please, my lord. The actual additional volume index.
It's slightly confusing, but we have one bundle which includes, we only have, and apart from a few documents in paper, we only have an electronic bundle. And it includes within it the primary bundle, the additional bundle, and a supplemental document.
Sorry. I know I'm trying. Forgive me, my lord. Just give me allow me just one opportunity to get that. Yeah. It starts at page 839, my lord.
Thank you.
Yeah. My lord, can I just indicate that in relation to this authority, these were 2 minors who came on the same pirogue with the appellants in this case. It was both similar to the facts of this case. It was a mother and a daughter, but both of them were minors. They brought similar habeas corpus proceedings before the High Court to challenge their detention. And the first instance judge, Madam Justice Gobin, released the applicants from detention. An appeal by the Chief Immigration Officer was lodged, and it was heard as a conjoint appeal with the appeal in this case. If I can ask the court to go to page 844.
Yes.
You have it, my lord? 844. And line 16?
Yes.
Section 16 as I read a minute ago, authorizes the detention of persons pending deportation. This is a non-judicial detention. It is a statutorily conferred power and must be exercised with meticulous adherence to the statute. An examination of the facts of this appeal confirms that no deportation order was made in respect of the respondents. The precedent fact for the detention was absent. Yep. There was no pending deportation, and therefore there was no trigger for the exercise of the power conferred by Section 16.
Yes.
And I think that it would assist the court if I can ask you, my lord, to go over to page 845 and to line 20 of that page. You see, Madam Justice, Dean Armorer says there, the fact that a person is an illegal immigrant does not in itself authorize detention. Such illegality provides a good ground for the issue of a deportation order, and the illegal immigrant may be detained pending deportation. Whereas in this case, there is no prospect of deportation. There is no justification for detention. The respondents in this appeal were, however, detained for another reason. They were detained because they were minors, and the CIO detained them pending arrangements of the Children's Authority. This is not a ground under the Act. There is no power conferred on the minister to detain pending arrangements with the Children's Authority of Trinidad and Tobago. Yeah. Now, my lord, I think reference to this passage takes us back to the conversation that we were having a short time ago, which is, one can easily say, if you have two children who are minors and they have no one in the jurisdiction to look after them, and they come before the court, and the respondent says, well, I'm going to continue to detain them until someone comes forward and until the Children's Authority does what they have to do, because we can't just release them. One can think that sounds very logical in terms of the welfare of the children, but you can't, in my respectful view, my lord, continue to legislate, and I use the word legislate very, very cautiously, in terms of explaining to the court. You cannot create additional categories of headings or instances where you can expand the Section 16 power so that it falls within the discretion of the executive to simply make it up as you go along. And this is a classic example of that. One understands, my lord, and I go back to the question that Lord Stevens said, one understands that in these circumstances, there are certain inherent risks in releasing someone. But, my lord, the question that one has to ask is that a matter for the court or is that a matter for the legislature in the circumstances? So I cite...
If I can interrupt you just for a moment as a question. The court, I mean, one of the points you make is that the court ought to be considering the welfare of children in a case involving a child. Now, if it did so in a case like the present, and if it considered, for one reason or another, either because of there was no lawful basis for detention in terms of a deportation order, or because there was a breach of the Hardiel-Singh principles, if it had concerns about the welfare of the first appellant, are there ways in which that could be addressed? I mean, are there, for example, is there the possibility of urgent care orders being made in Trinidad?
I'm happy that my lord has raised that issue, because it is something that the Immigration Act provides for, and there is an authority that we have provided to the court, and it's a very important authority, albeit that is a first instance judgment of then Justice Kokaram. That is the matter of Troy Thomas, And the vice in that case, and I don't mean to stray off of it, I'll take you to the authority, but the vice in that case was this. The Director of Public Prosecution in that case was making a decision as to whether to continue to hold someone because they had criminal proceedings pending before the court. And there was a clash, if you were to say, between the power to exercise by the Director of Public Prosecution to continue a criminal prosecution and the ability of the immigration authorities to hold. The immigration authorities said, we're holding, but we're holding because we're waiting for the Director of Public Prosecution to make a decision on this individual. And in the end, the judge came down on the side of allowing the applicant to be released. But what was more important, my lord, in that judgment is this. The judge specifically gave guidance as to how this Section 16 power was to be used. And having set the narrow parameters of Section 16 and expressed his view as to the fact that you can only detain for the statutory purpose, Justice Kokram went on to indicate the Immigration Act provides under Section 17 the ability of the Chief Immigration Officer or the Minister to be able to issue orders that allow persons to be released in circumstances where it is clear that deportation is not going to be a realistic possibility in any time soon. And that, my lord, is a very important provision, because in answer to the question that you've just asked, it is easily answered by the Chief Immigration Officer exercising his discretion under Section 17 of the Act and saying, in these circumstances, we will release this person, put them in a care home, have them monitored, impose whatever conditions that one can impose. And that brings me back again to the question that Lord Stevens asked, which is this. If it is that the statute does not permit you to detain someone in circumstances where the statutory purpose cannot be carried out, but the legislature understood that to be the position and provided the Section 17 power for someone to be released on an order of supervision, it is within the discretion of the Chief Immigration Officer to exercise or to impose whatever conditions he considers necessary, whatever reporting conditions that can temper the risk of bail or the risk of reoffending. The Section 17 discretion that is given by Parliament to the Chief Immigration Officer, my lord, if I can draw an analogy, it's like an application for bail. It allows the Chief Immigration Officer to impose whatever conditions he considers necessary in relation to the release of that person, but at the same time satisfy the statutory purpose for which the Section 17 power was given. Because it is clear, my lord, that the legislature understood that there will be circumstances in which you would want to release somebody pending deportation because you simply cannot carry it out. And the examples that the case law provides, the person in relation to Tantilam, where you couldn't send people back to Vietnam, or in R&I, where you had an issue with Afghanistan, and you couldn't send people back to Afghanistan, or arrangements couldn't be made. And I can say I hope that I'm permitted to say from the bar table, Miller, that there can be many administrative issues, the acquiring of a visa, making appropriate travel arrangements. These are all obstacles that can arise in the process of removal, where the deprivation of liberty doesn't have to be sacrificed while these issues are being sorted out. So that the answer to the exercise of that power in the way in which Justice Kokaram, as he then was, explained in Troy Thomas Miller, to temper the hardship of depriving someone of their liberty. If it had been exercised in this case, we wouldn't be here.
And the court impose conditions if it decides that a person's detention is for an unreasonable period of time? Or is that a power just simply in the minister under Section 17? If the court makes a decision to say that the period of time has been unreasonably long, is the only option available to it,
My lord,
just to order the release of the individual.
my lord, I'm very happy that you've asked that question because I wish to answer it in two ways. As I want to answer it and say, and Mr. Hussein and the team for the respondent can indicate whether this is so or not. My experience has been that where habeas corpus applications are made and the court finds that the detention is unlawful, in some cases, what the order that the court makes is that that person be released on an order of supervision. And there are written judgments to that effect, so that the court itself will find that the person is detained unlawfully and then makes an order that the chief immigration officer can release that person on an order of supervision. And in releasing the person on an order of supervision, in most cases, what the practice of the immigration authorities do is that they would release them on the provision of a bond. And the bond would usually be the value of the ticket to go back to the country, to go back to the country that they are to be deported to. Now, the second answer I want to give to that question, Lord Stevens, is this. I would submit that on a strict interpretation of the jurisdiction in habeas corpus proceedings, I would say that if a court finds that someone's detention is unlawful in habeas corpus proceedings, the only option that is available to a court as a matter of strict jurisdiction is to release. I don't know that a court on a habeas corpus application has the jurisdiction to impose conditions on the release of someone where they have found that there is no lawful justification for their continued detention. So that is the best way that I can answer it, Lord, as a matter of practice and as a matter of strict law. So, my Lord, in relation to the way in which the case has come before this court and the grounds that have been advanced, we say that in relation to the first name appellant, there is no lawful justification in the absence of a deportation order. And we say that the first name appellant ought to be released forthwith. We say that with respect to the deportation order that has been issued last night, that deportation order on the authority of Torres violates the injunction order and provides no lawful justification for the continued detention of the first name appellant. And in support of that, we also say that the express terms of the Immigration Act provide that the only way in which someone can be detained under the provisions of the Immigration Act is upon the issue of a deportation order. And we say that on the authority of Navarro-Gobin in the Court of Appeal, that the precedent fact in relation to the first name appellant was absent. And if that precedent fact is absent, there is no basis upon which detention can occur. And I would respectfully ask this court, having regard especially to the fact that the infant minor in this case has been detained for 14 months, less 1 day, since the making of the injunction order on the 18th of January, 2021, should be released forthwith. On the question that Lord Reid had indicated earlier, and the answer that I gave with respect to Section 17, and the issue that my Lord raised with respect to the best interest of the child, my Lord, was open from the time that the conditional leave application was filed for conditional leave to come to the Privy Council was filed. The father of the infant had come forward and gone on affidavit. And therefore, the respondents would have been aware that the father of the applicant, they would have been aware of the existence of the father, and they would have been aware of the fact that he was a registered UNHCR migrant, refugee, registered under the United Nations High Commissioner for Refugees. And one can easily envisage that a proper application of the power under Section 17, together with an application of the best interest principle of the child, would have led inevitably to that detention being brought to an end, notwithstanding that these proceedings were on foot. But that has not been an option that the authorities have adopted. They have chosen instead, my lord, to seek to justify the detention and the further detention by the issuing of a deportation order, which we say, my lord, can provide no lawful justification. Unless I can assist the board any further, my lord, can I go on to the case with respect to the second appellant?
Yes, certainly.
With respect to the appellant number 2, my lord, we say that the distinction that is apparent from the decisions in this appeal and decision in Torres, that it makes a difference whether the order was made before, the deportation order was made before the injunction order, or the deportation order that was made after the injunction order. Is really a distinction that carries no legal difference in terms of consequence. I say that, my lord, because the basis upon which the Court of Appeal found that there was lawful justification in relation to the second name appellant in this appeal was that there was a valid deportation order. The Court of Appeal did not apply the Torres reasoning. And one has to ask itself, my lord, does it make a difference? Does it make a difference that the order, the injunction order, are in the same terms, but the deportation order in one case is made before and in one case is made after? Well, I think my answer to that has to be, my lord, that in the case where it is made, where the injunction order is made after, it becomes even worse if you apply Torres. Because Torres, the rationale for Torres is that the making of the deportation order is in breach of the injunction order, and therefore is void ab initio. If you apply that reasoning to this case, you come to the position where you have a deportation order that is made when there is no injunctive order. The injunctive order then comes, and the detention that is pursuant to the deportation order under Section 16 continues beyond the injunction order.
But if the order is made at a time when there is a deportation order and they're being detained pursuant to that order, it prevents you from taking any steps. That's further steps.
And that's the point.
I mean, further steps than already existing.
It would have been already existing, my lord. One, we have no question about the period between the 12th and the 18th, because we have, as I explained before, when the order was made on the 12th, there was no injunction. I seem to have lost you, my lord.
No answer.
Yeah, so when the order was made on the 12th, there was no injunction.
Mm-hmm.
Let's assume, my lord, let's just assume, without admitting that there was lawful justification to detain pursuant to that order between the 12th and the 18th. You're detaining pursuant to the deportation, you're detaining pursuant to 16, which is the deportation order is a condition precedent to the exercise of the power under 16. But my lord, on the same reasoning, if you can't make the deportation order, you obviously cannot authorize detention pursuant to that deportation order. if you have the order on the 12th and there is no injunction order in place and you proceed to detain, detention can only be pursuant to a deportation order under Section 16. If on the 18th the order is made and it prevents you from taking any, well, I don't want to use the word taking any steps, it prevents removal. Detention is a step towards removal. And therefore, if you are detaining and the order is made, preventing you from removing, and the only statutory basis, the only lawful exercise of power that can be done under Section 16 is to remove, then you have to bring an end to the removal to comply. You have to bring an end to the detention to comply with the order. And therefore, we say that from the 18th of January 2021 till today and continuing, the detention has to...
You say the continued detention was taking a step to remove?
Well, it must be, my lord, because under Hardyal Singh, the only basis upon which you can effect detention under Section 16 is to remove. If we use Lord Dyson's words, to facilitate deportation. So if the only purpose that you can lawfully detain pursuant to Section 16, there can be no challenge to that. The only purpose for which you can detain under Section 16 is to remove. That is what the authorities say. So that if the authorities say the statutory purpose is to facilitate deportation, I say let us assume that the initial detention was for that statutory purpose. When the order is made on the 18th, you can't continue to detain because the order itself is what prevents you from acting pursuant to Section 16.
Mr. Ramdeen.
Yes, my lord.
In the case of these applicants, at first instance, Madam Justice Mohammed, at paragraph 5, it's page 76 of the bundle.
Sorry.
In the second part of paragraph 5, page 76 of the bundle.
Yes, my lord.
Said, in my opinion, the order of Quinlan Williams, Madam Justice Quinlan Williams, made on the 18th of January 21, restraining the deportation of the applicants pending the determination of substantive constitutional proceedings concerning the applicants, did not invalidate the deportation order, but temporarily prevented the respondent from taking any further steps to give effect to it.
Yes, my lord.
And that's taken up in the Court of Appeal at paragraph 33 on page 94 of the bundle.
Yes, ma'am.
Where it's that passage, that sentence is repeated. The Court of Appeal simply says, but the judge fell short of exploring whether in all the circumstances the period of detention was unreasonable. They then go on to consider the Hardyal Singh point.
Yes, ma'am.
But they don't seem to express any conclusion in relation to this point, which is the Torres point.
Well, my lord, it may seem to be shocking to you, my lord, but it's the same Court of Appeal judge writing both judgments. Torres came after this. And one, in the same way that one can ask the question, how is it that one could have, when the passages that I read from Gubin Navarro, the Keren case, with the two infants, the facts of Jesus are exact to the facts of those two individuals in Keren and Gubin. They're exact. So when this judgment was given, Jesus was a minor that had no deportation order made in relation to him. And I remind the court that these appeals were all heard together at the same time. So Jesus, who is the first appellant in this appeal, was on all fours with Keren and Keisha. And the court found that Keren and Keisha, there was no deportation order. They ought to be released because the precedent fact was not satisfied. But that exact factual matrix caught the first name appellant. Now, my lord, the same question that you've asked, which is, there's no difference between the facts of Torres and the facts of the second name appellant. So how is it that the court was able to reason 2 months before, in the same appeal, where all of the arguments are heard together, that the Torres principle didn't apply to the second name appellant in this appeal? The only distinction, in fact, between Torres and the second name appellant in this appeal is what I indicated to the learned President Dodd Reed, that in one, the order was made before, and in one, the order was made after. And I'm saying, as a matter of legal logic, it can make no difference whether the order is made before or it's made after.
Yes, thank you.
Could I just get your assistance in relation to a factual matter? The order that was made by Mr. Justice Rahim is at page 26. And when the judge granted that injunction, were there any submissions, or was there any indication that he was contemplating preventing detention as opposed to preventing removal? Because if he was contemplating that by his order he was preventing detention, he would have weighed in the balance risks of absconding, risk of offending, and all the other circumstances that would go with releasing somebody into the community. I was just wondering whether there was any submission at all before him about the effect of his order being that detention would now be unlawful.
My Lord, both myself and Mr. Hussein appeared in all of these proceedings in the court below. And as far as I can remember, and the record will reflect that, is that there were no arguments advanced with respect to those factors, because the only issue that was before the court at that point in time was the application for injunctive relief and whether the applicants were entitled to the injunctive relief sought on those applications.
So it's by a byblow, unwittingly, the judge has prevented them from being detained.
I wouldn't say unwittingly, my lord. An order has been made based on an application that is before the court, and the legal consequences that flow from the making of that order depend upon the manner in which the executive chooses to exercise the powers that are given under Section 17. It is, Lord Stephen, the answer to that question can simply be that when the order was made under when the interim order was made, whether it be by Justice Charles, Justice Rahim, or Justice Quinlan Williams, the order could have simply been satisfied by releasing the applicants under Section 17. And that would have been a lawful compliance with the order. And the Immigration Act provides for that.
Thank you very much. Thank you.
So, Milad, you have the very, I say respectfully, Milad, you have the very untidy situation where you have 4 appeals being heard together, and you have different judgments that are being given by the same judge that comes to different conclusions on the same facts and on the same law. And what is troubling about it, my lords, is this. When the Court of Appeal delivered the subsequent judgments on the 16th of December, and my learned friends in the respondent's case seek to give an explanation as to why the Karen Keisha decision was different from the Jesus facts in this case. They say, that is the respondents say, well, that could be explained by the fact that in Keisha and Karen, they had no guardian with them. They were unaccompanied. Whereas in Jesus, he was accompanied. But the difficulty with accepting that reasoning is that Madam Justice Dean Armorer, who was writing the judgment in the subsequent matter delivered on the 16th of December in Karen and Keisha, didn't make that distinction.
Karen and Keisha are the same as Navarro and Govin, is that right?
Yes, my lord.
Yes.
Yes, my lord. Yeah.
17-year-old and her...
That is correct, my lord.
Yes.
May we just see that again, please? The passage in the Court of Appeal judgment where that distinction isn't drawn, the point you were just making.
Yes, my lord.
Could you just give us that reference again, please?
Court of Appeal. Yeah. Yeah. The Karen and Keisha authority, my lord, is to be found at tab 2. The electronic bundle number is 844. The line numbering is line 16 to line 25. And the
Section, the sentence beginning section 16, as I read a minute ago.
sorry, my lord?
I'm on page 844.
On page 844, line 16, starting section 16, ending section 16, that paragraph?
Yes, thank you.
And
Where do we see the distinction drawn between Navarro and Govin on the one hand and the present case on the basis that Jesus did have a guardian?
my lord, sorry. My lord, that is in the respondent's case. Can I get...
I understand it's in their case. It's not referred to in any of the judgments in the Court of Appeal.
No, that's the point that I'm making, my lord.
Yes.
The point I'm making is that the Jesus, the first name appellant in this appeal, is on all fours factually with the facts of Karen and Navarro, Keisha. And there is no distinction in the judgment that is given on the 16th of December.
Thank you.
To apply the same principle. And I say the same thing, the same difficulty, or
Well, you commend that passage to us in the reasoning on page 844.
yes, my lord, I do. It falls in line with the principal submission that we make in relation to the first appellant. Without this passage, I would still make this submission that on a strict interpretation of the Immigration Act, the detention, no detention can flow unless there's a deportation order, which is simply what this passage says. So that my submission is that on a proper reading of the Interpretation Act, if there is no deportation order, there can be no Section 16 detention and no lawful justification ab initio for the first named appellant.
But we're now looking at the second appellant's case.
On the second appellant, my lord, I'm saying you have a similar difficulty because the Torres judgment that I commended to the court
Right, well,
and the facts of Luisa, the second appellant in this case, are on all fours, save and except for one distinction, which is that in this case, the order for interim relief was granted on the 18th, which is after the deportation order, and in Torres was granted before. And I'm saying that whether it's granted before or after, it makes no difference.
But well, it makes it, well, it does have the it does mean, I think, that you're asking us to read the order made on the 18th as impliedly prohibiting the status quo which existed on that date.
On the basis of the terms of the order, my lord. Because if one has to take one step back respectfully in the reasoning to apply the common law, the way in which the common law has indicated that the power under Section 16 can only be exercised for one purpose, which is to facilitate detention. To facilitate deportation. If that is correct, and that must be correct, when the order is made on the 18th, and the order says to prevent any step towards removal, detention under Section 16 is only permitted for the purpose of removal. It's not permitted for any other purpose.
Yes, I understand that. Another way of putting the point would be to say that if the judge had meant to prohibit detention, she could simply have ordered their release.
Well, the answer to that, my lord, is simply that the judge is entitled to make the order, and the respondent ought to have complied. And having made the order, the consequence was that the respondent would have ought to have known that they could not continue with detention, because one is entitled, my lord, to sit in the shoes of the respondent and say, well, why are you making an order ordering release when that is a matter for me? I have not breached the order. I have an opportunity to comply with the order, and if I comply with the order, I'll release it mandates that I cannot continue the detention. So respectfully, if that submission that has been made by the respondent is answered by the fact that compliance with the order would have led to the applicants being released in any event, and why would a court preempt the respondent from complying with its order by making an additional term of the order that there is no basis upon which to make at the time when that order is being made? And for which, my lord, I ought to remind, and for which that order was not sought in the application for interim relief. So we say, my lord, if the effect of the order on the 18th of January 2021 was to injunct or restrain the Section 16 power, then you could not lawfully continue detention beyond that period of time, based on the order that was made. The authority, my lord, of Naidiki makes it very clear, and all of the authorities, especially Lombard, makes it very clear that the only purpose for which detention can be exercised under 16 is to facilitate removal. To use the words Lord Lloyd Jones had indicated earlier in pointing to the exact terms of the order says step towards removal. Step towards removal. Detention.
It doesn't say step towards removal. It says steps to remove.
Steps to remove.
That's my point.
Right.
Steps towards removal was a gloss put on it by the Court of Appeal in Torres.
Right. But steps to remove, my lord, on the facts of this case and based upon the statute that we're dealing with and the manner in which the statute ought properly to be applied, detention pursuant to 16, and the respondent hasn't alleged otherwise, detention pursuant to Section 16 can only be a step towards removal. And if that is prohibited by the order, then you just simply cannot do it beyond the making of the order.
Can I ask you one or two questions about the welfare of children as a consideration?
Yes, madam.
In this country, the Home Secretary is under a statutory duty to have regard to the interests of children when exercising her immigration powers.
Yes, madam.
Is there anything analogous in the law of Trinidad?
Well, I have provided the court with the authority of SS versus the Chief Magistrate.
Thank you.
And the purpose for providing that authority, my lord, is to be found, if I can, the reference state is electronic bundle 1002.
Yes.
And this was a matter in which our Court of Appeal in Trinidad set out a number of things. Firstly, it recognized that the core principles of the United Nations Conventions on the Right of the Child were expressly incorporated in domestic law in Trinidad, and that is at paragraph 28 on page 1003.
Yeah.
And it goes on to accept that Article 3.1, if you look at footnote 49, my lord, which comes from paragraph 35, that Article 3.1 of the United Nations Conventions on the Right of the Child is an accepted principle that has been incorporated into our domestic law.
Yes. Now, that article says in all actions concerning children, that would certainly cover the first appellant, as you say, on your argument, the first appellant's case is a very simple one because he's just not been lawfully detained.
Yes, ma'am.
And we've got this problem about the recent order. What about the position of his mother? You see, are the interests of the child a relevant consideration so far as she's concerned?
Well, on the answer to that question, Millard, is found in the speech of Baroness Hale in Naidiki, and that is in our principal bundle.
Oh, fine. Thank you.
Page 667 of the electronic bundle.
Right. Thank you very much.
And specifically paragraph 71, 72.
And if, just to take a hypothetical case, if the court were to order the release of the first appellant, but not the second, what would actually happen?
My lord,
what would happen to the child?
I didn't get the last part, my lord. Pardon me.
What would happen to the child?
Well, there are two things that arise on the facts. Are we dealing hypothetical or on the facts of this case?
Well, in this case, hypothetically, if this child were to be released, for example, is the father in a position to look after the child?
Yes, my lord, and that is why I made the point that the authorities would have been aware that the father was a registered United Nations UNHCR registered. The father was a registered UNHCR refugee,
resident in Trinidad.
Yes. And
a refugee, not an asylum seeker, a refugee.
Yes, my lord, he was registered.
My lords, I hesitate to interrupt. This is completely new. There's no evidence of this in the record.
Right. Yeah, well, it's a that may be one of your problems, Mr. Knox, in a way.
Well, I think that's not for us to give evidence on. I take your lordship's point on other matters, but that, what can we say to that? This hasn't been put to us at all. And we dispute it, but I'll come to that later.
Okay. Well, I understand the point that Mr. Knox is making. But it's clear, I mean, it rather looks as though this sort of question hasn't been gone into previously.
Well, my lord, I can answer it from the perspective, the question that my lord has posed, I can answer it from the perspective of saying, I understand Mr. Knox's position, and I'm not going to try and bring in evidence that is not there.
Yeah.
But Section 3.1 under the United Nations Convention and the best interest principle would require that even if a court were to take into consideration that the minor child is unlawfully detained and ought to be released, it automatically flows from an application of Section 3.1 that a relevant consideration has to be the best interest of the child in those circumstances and how the best interest of the child would be satisfied in those circumstances. And I go back again to say that if it is that the court is required to consider that as a matter of application of the convention, the public authority that is responsible for the detention is also required to take that into consideration in exercising their discretion as to whether to detain or not under Section 16, and the ability to exercise, or the opportunity for them to exercise their powers under Section 17. So that the fact that I am unable as a matter of evidence to submit to you what is the position with the child doesn't disallow the court from taking into consideration the best interest principle.
Yeah.
Neither does it disallow neither does it absolve the respondents from the responsibility of considering it as well, from considering it as well throughout the detention.
Yes. Thank you. Now, is there anything else you need to add, Mr. Randine? I'm just keeping an eye on the time.
Yes, my Lord. I'm going to try to see if I can deal with the last issue, which is the issue that was dealt with by the Court of Appeal about the reasonableness of the length of the detention.
Yes.
And we have quite, if I can say so, my Lord, I hope my Lord will agree, we have quite comprehensively addressed that issue in our written case. As we've set out in our written case, the factors that ought to have been taken into consideration by the Court of Appeal, but were not. And that starts, my Lord, at electronic bundle, page 483. We've provided the references throughout with respect to the different factors and the authorities in support of each of those factors. What is clear on the authorities, my Lord, is that if I can start by saying, Madam Justice Dean Armour in the Court of Appeal took a very broad approach that once the constitutional proceedings were afoot and were being prosecuted, then the detention that flows therefrom would fall within the band or the remit of being reasonable. And we have submitted in our case that amounts to an acceptance of the exclusionary rule that was advanced by the respondent in Lombard. Lombard is authority for the proposition, my Lord, that the exclusionary rule has been rejected. And that each case turns on its own facts.
Yeah.
Now, the answer, where the Court of Appeal got it entirely wrong, my Lord, is pursuing the reasoning that the detention in this case was self-imposed, because the applicants could have easily ended their detention by withdrawing the interim injunction. And then the natural consequence from that is that they could have been deported. Now, that in and of itself, my Lord, is an acceptance by the Court of Appeal that the interim injunction prevented the deportation. and authorize the detention. But more importantly, my lord, well, can I take the court to page 717?
Yeah, do bear in mind that you've currently got 5 minutes left of your reply time. You're eating into your time all the time.
But can I ask the court to go to page 717?
Yep.
And what Lord Dyson says at paragraph 127, 5 lines from the bottom, my lord.
Yes.
And I think this is a complete answer to the reasoning of the Court of Appeal. In accepting voluntary return, the individual forfeits all legal rights to remain in the United Kingdom. He should not be penalized for seeking to vindicate his ECHR or Refugee Convention rights and be faced with the choice of abandoning those rights or facing a longer detention than he would face if he had not been offered voluntary return. That is exactly the choice that Madam Justice Dean Armour gave, or her reasoning is based upon, that the applicant ought to make a choice as to whether to continue to pursue the proceedings under Section 14 or withdraw the proceedings under Section 14 in order to get your liberty and just simply be deported. And that is not a proposition that is permissible, my lord, in my respectful view.
Yeah.
When one considers, my lord, I'm just going to try and wrap it here up, my lord. When one considers all of the factors, this is what the case with respect to the reasonablest of time boils down to. Having regard to the facts of this case and the nature of the constitutional proceedings when the habeas corpus proceedings came before the High Court, it was clear that deportation could not take place within a reasonable time. The Court of Appeal accepts that the High Court Judge, Madam Justice Mohammed, was wrong in not considering that factor at all. When the proceedings came before the Court of Appeal, the Court of Appeal itself said that the detention was not unreasonable, but they expected that the proceedings would come to an end by the 31st of December. We say there was no likelihood when judgment was given in the Court of Appeal that deportation could have been within a reasonable time. And what you have before you now, my lord, is a situation where it is undisputed that you have applications before the court for striking out of evidence, a recusal application that has been pursued by the respondent. And, my lord, before I conclude, can I simply just point out to the court that in the respondent's case, at paragraph 40 of the respondent's case, which is at page 503.
Yes.
The respondent lists a number of factors from 1 to 5, and you will see in those paragraphs, and this is the point I quickly wish to make, my lord, you will see in those, in support of the reasonableness argument that the respondent is advancing, that there are a number of paragraphs that the respondent has cited in the constitutional proceedings. What the respondent has not indicated to the court, my lord, is that save and accept paragraph 31 of the Gary Joseph affidavit, all of these paragraphs that have been cited here are subject to be struck, are the subject of the striking out application before the High Court.
All of them except 41.
All of the paragraphs, save and accept, you will see
It's Gary Joseph.
Gary Joseph, paragraph 31, page 350.
Yeah.
That is the only paragraph that is not the subject of the striking out application.
Thank you.
So when people seek asylum, in inverted commas, in Trinidad, are they relying on the Constitution of Trinidad?
In this case, my lord, we are relying on the Constitution to say that the protection of the law that is guaranteed under Section 4B allows you to have the right to seek asylum.
Yes.
There's no right to asylum, but it allows you to have the right to seek asylum.
I understand.
And, my lord, the last point that I just want to quickly indicate is that when you look, my learned friends have advanced a submission that the substantive proceedings are hopeless. And I wouldn't have the time to go through all of the paragraphs, but if you look at the judgment in the Valeria matter, which is the appeal that went to the Court of Appeal where injunctive relief was refused, there are two things that I wish to say about that. Firstly, my lord, that judgment contains several references in which the Court of Appeal has held that this case is one that requires to be determined at a trial because there is a serious issue to be tried. And on the injunctive principles of the grant of injunctive relief, one of the ingredients for the grant of injunctive relief is that you must have an arguable case. And if you have a case that is hopeless, a court will not grant injunctive relief to restrain a defendant in a case that is hopeless. But there are paragraphs throughout the judgment of the Court of Appeal where the Court of Appeal identifies all of the issues that are arguable and the basis upon which the Court of Appeal finds them to be arguable. And the only difference, I think it's proper for me to indicate to the court, that the only difference between the Valeria constitutional motion, the Valeria application for interim relief, was that was in relation to a child, so that the references to ZH, the decision of the House of Lords in ZH, and Supreme Court, and the best interest principle, that issue is the only issue that is different in that case from the issues of the protection of the law and the application of legitimate expectation in a constitutional setting that arise in the constitutional motion in this case. And I ask you to take into consideration those factors and find that submission is one that is not with merit. In those circumstances, my lord, unless I can assist you further, that is the case for the appellants.
Thank you very much, Mr. Randine. Mr. Knox.
My lords, could I just summarise briefly what my submissions are, and then I'll go on to elaborate them. First of all, I say that on the issues raised before the Court of Appeal, that hearing took place on the 1st of April 2021, on the issues raised before the Court of Appeal, their judgment is entirely correct. No point was now taken, as it is now taken before you, to the effect that the detention of the son, the first appellant, was unlawful because there was no separate detention order against him. That point simply wasn't run at all, either in the written arguments or at the hearing. So, not very surprisingly, you don't see any reference to it in the Court of Appeal's judgment. The second point is this. The argument in relation to Hardiel Singh was not that so much time had gone by the 1st of April 2021 that the continued or future detention was going to be unlawful. That simply wasn't actually argued before the Court of Appeal. Different arguments were raised, which I'll come to later. The Court of Appeal then, as you will have noticed, took about 3.5 months to write their judgment, which came out on 21st of July 2021. But no further submissions were made in the meantime between the 1st of April and 21st July 2021. So we say the Court of Appeal's judgment was entirely correct given the issues which were raised before it. What appears to have happened in relation to the Hardiel Singh point, when they went on to consider has enough time gone by and when will the judgment in the constitutional proceedings be given, they seem to have done that of their own motion. So we say, did the Court of Appeal do anything wrong, bearing in mind the arguments raised before it on the 1st of April or thereafter? Answer, no, not at all. Secondly, we say it follows from that the correct disposal of this appeal is that you should dismiss it because you are not a second Court of Appeal. You have to satisfy yourselves that the Court of Appeal acted correctly, and if in my submission they did, then it's not right that you should go any further than that. If there are any further applications that the appellants or one of them wants to make, that is a matter for them to make in the courts below in the light of subsequent developments. I do also emphasise this. We've got to remember what this action is all about. It's a habeas corpus. It's a habeas corpus action. There's nothing to stop on the face of it the first appellant, if he wants, to apply under the Children's Authority Act for him to be taken into care separately from his mother. That has never been prevented from doing that. They just haven't done it. And I do submit also that fundamental point, that what the nature of these proceedings is, must inform your Lordship's approach as to how to deal with this appeal. Secondly, my Lords, we say this: insofar as you do take into account the new issues...
I'm interrupting. What are the grounds for a child to be taken into care separately from his mother? What does he have to establish in order to achieve that?
Well, my Lords, as we understand it, there is... my Lords, I'm going to have to check this over lunch because I've only recently seen the statute, but there's a Children's Authority Act which provides for, which I'll, if I may check exactly what it says, but it does provide for a child to be taken into the care, effectively, of the Children's Authority in Trinidad, if it can show one of a number of different things.
But abandonment would be one. Failing to provide proper care, such as to cause a substantial risk of serious harm, would be another, I would assume.
My Lords,
for the life of me, I can't think of anything that would meet the facts of this case.
No, well, my Lords, I will have to check what the... There are a number of different grounds in the Children's Act, Authority Act rather, which are set out. My Lords...
Was the child ever told his right to do so?
My Lord, there's no evidence that he was.
Yep.
But the real problem, my Lord, is the whole question of the distinction between the mother and the child simply wasn't drawn in the courts below at all, except on one occasion, which I will mention later, but an irrelevant occasion. That is the underlying problem with the evidence in this case.
When making a return to the habeas corpus application, did the minister draw the distinction and justify
yes.
and on what basis did he do so?
Well, if I may, in due course, I'll take you to the correspondence and the return, but broadly in the correspondence, shortly before the deportation order was made, I think it's the minister or the chief immigration officer does in turn say what the child, what can happen to the child, is there someone else who can take the child into care? That's one of the points he expressly raises in his letter. In the return, the chief immigration officer, from recollection, simply says that the son is in the care of the mother. Mm-hmm. And that is the justification on which he is in the care of, and that is therefore the justification for his not being released.
For detention.
Sorry?
That's the justification for detention.
Well,
as opposed to for detention.
Well, my Lords, I can get into a philosophical argument, but so that is the justification for his being there together with his mother, because he's in the care of his mother. But I don't want to split hairs on that, but that is how it's put in the return. The difficulty is the point just wasn't taken, it seems, in oral argument before the judge, and certainly wasn't taken in the Court of Appeal. That's the underlying problem in this case. And so no evidence is addressed to any of this. And what should happen. But my Lords, our point is, if the child does want to be taken separately into care, there's nothing stopping that at all. All that's happened so far is there's a deportation order and detention pursuant to it. But that doesn't prevent the child making whatever applications are appropriate, either before or subsequently.
There are proceedings concerning the child insofar as his deportation was envisaged, either as a matter of the fact that he was accompanying his mother, and the state has an obligation to consider, as a primary consideration, his best interest. And to discharge that obligation, what do they do?
Well, my Lords, I think at the moment I can't give you any other answer than the one which I have given, which is they have not themselves taken any specific steps. They have left it that the child is in the care of the mother, and the mother, on behalf of the child, hasn't taken any steps to have him treated separately from herself. Although there was an invitation, my lords, I will come to this, there was an invitation or a question asked by the, I think it's the Minister of National Security or the Chief Immigration Officer on the 12th of January as to how do you want the son to be dealt with. But since then, the fact of the matter is this litigation is run, so to speak, without, I think I'm right saying this litigation and indeed the constitutional motion has been run without any real distinction being drawn between the two. That's the underlying problem. To which your lordship says, well, it's the state's responsibility in any event. My lords, that is right. But on the other hand, it's not that easy for the state to intervene when the son is in the care of the mother and they don't themselves seem to want to be separated from one another.
Well, Mr. Knox, we're going to have to adjourn in a moment, but whatever the previous history of the case, it's apparent that we do have a number of issues being raised before us,
Yes.
which we'll have to deal with. And insofar as there may be merit in some of them, obviously we'll be discussing.
Yes.
Insofar as there may be, there's going to be an issue for us as to whether we then try to deal with them ourselves or remit the matter back to the courts in Trinidad.
Well, my lords, and we apologise for the lateness of our note the other day, but it did occur to us that this could be really a rather difficult and unsatisfactory exercise for the board at this stage, with sort of half bits of information here and there, or simply on a return to habeas corpus writ.
Well, for example, if we think that the best interests of the child ought to be taken into consideration, we're not in a position to hear evidence about that.
No.
Well, we'll adjourn then for the moment and sit again at 2 o'clock.